On March 20th, 2025, defendant Byron Laws appeared before Judge David Fletcher in the Harris County Criminal Court in Houston, Texas, in connection with a pending charge of driving while intoxicated with blood alcohol concentration greater than 0.15. The alleged offense arose from an incident dated October 5th, 2021. According to law enforcement, officers were dispatched following a report of a possibly intoxicated driver observed weaving between lanes. After initiating a traffic stop, officers noted indicators of intoxication, including bloodshot eyes, balance issues, and the odor of alcohol. Field sobriety testing reportedly revealed multiple clues of impairment, and a breath test measured a BAC of 0.15. Mr. Laws had been arrested without a warrant and subsequently charged by information filed by the district attorney. Recently appointed defense counsel, Anna Eddy, reviewed the case and requested that the court revisit whether probable cause supported the original warrantless arrest. Counsel relied upon constitutional protections articulated in Gerstein v. Plea and Texas Code of Criminal Procedure Article 14.06, both requiring a timely judicial determination of probable cause based upon sworn facts. Counsel argued that the Sworn District Attorney Intake Management System, DIMS, summary lacked sufficient factual detail to justify the arrest, thereby challenging the legal foundation of the charge.
On Laws.
Okay.
Is the last name. He's on bond.
Okay.
He has a BVR, but can we hear PC on this one?
Sure.
All right, there's this.
You don't think there's PC?
Laws.
No.
Yes.
You don't think there's PC?
I don't, looking at the DIMS, but reasonable minds can disagree, Judge.
Have we done PC on this before?
I don't know. This is an older case and I just got appointed on it last month. So.
Did you already approach on PC on this?
I have not.
Don't worry about it.
I'll just be honest, Judge. I had assumed because of the age of the case that PC had been done. But
Of course it has been.
right.
But there's a new set of eyes, you know? Okay, ready?
Yes, Your Honor. Sorry, just reading through it. 2021 case. Thanks, sir. All right. On October 5th, 2021, the officers were dispatched to a DWI call. Excuse me. Adjudication. Okay. Officers were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes as well as making a turn on the highway, heavy traffic. The officers conducted a traffic stop. The officer observed the defendant to have glassy eyes, slurred speech, an odor of an alcoholic beverage, and poor balance, and a article with quiet, please, hold beer inside the vehicle. The FMSTs were conducted. It was a 6 out of 6 on the ATN, a 7 out of 8 on the walking turn, and a 4 out of 4 on like stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address, and there's no reason given in the DIMS for the stop.
She read something different.
That was
Yes.
not in the DIMS.
That seems to be from the offense report.
Sure, I mean, what's...
But I thought for PC, we just used the DIMS because that was sworn to, and not getting into the.
Show me where it says that. I don't know of any rule that says that it's PC has to be done on just the DIMS.
Okay.
You know, I don't. If you can direct me to something,
Okay,
but I've
and
never.
that just may be my misunderstanding of a
Yeah,
policy.
I don't. And I've heard this before.
Okay.
Right, but I can't. I've never seen anything where someone has ever directed me to saying, "Hey, PC is only
Well, it's
has to be just on the DIMS." You
because
know.
the DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into
Sworn document too.
the offense report's on a sworn document.
I mean, I guess, Your Honor, my thing is it's a public record that they're using DIMS taking the offense report. And also, I have never seen it where we have to rely solely on the DIMS for public policy. It's probably law. In fact, when we go to the grand jury,
You asked me for a reset.
that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence. And that's probable cause.
Yeah, I don't know. I don't think that. I mean, let's look because I don't know.
At the outset of the hearing, defense counsel requested a renewed probable cause determination, asserting that the sworn DIMS report did not articulate a lawful basis for the initial traffic stop. Specifically, counsel argued that the DIMS entry merely stated that officers initiated a stop at a listed address, but failed to include the reason for the stop or sufficient facts establishing reasonable suspicion or probable cause. Counsel maintained that, under local practice and constitutional standards, probable cause must be evaluated strictly within the four corners of the sworn DIMS summary, not supplemented by later prepared offense reports. The prosecution referenced details contained in the offense report, including the witness's observations, the defendant's driving behavior, field sobriety test results, and the breath test reading. However, defense counsel objected to reliance on those materials, noting that offense reports are not sworn statements and may be supplemented or amended. Counsel cited the Harris County class action settlement in Lease v. Harris County, which required sworn factual statements within DIMS to support probable cause determinations. Judge Fletcher questioned whether the court was legally limited to DIMS alone, but acknowledged uncertainty regarding any rule permitting supplementation. The discussion centered on whether unsworn narratives could constitutionally satisfy Fourth Amendment requirements, prompting the court to pause proceedings to review the applicable legal framework.
You know?
Okay, I'll stand
And
down.
I'll,
Go check with
sure.
Ms. Roberts.
Yeah, I would.
Hey, you ready? Come on.
Yeah, I just want to approach on bond conditions for Mr. Bardin.
Okay.
B-A-R-D-S-O-N.
So you got appointed Mr. Albardan?
Yeah.
Great. Okay.
He has a residency restriction to stay away from his father's house. That's where him and his siblings live. And I want to approach you about lifting that up to no harmful or offensive conduct.
And I'm okay. So he's Mr. Albardan. Come on up. Your lawyer wants me to change the conditions so that you can go back to the house. But I want you to understand that if you have a very tumultuous relationship with these people where you're always butting heads with them, it's not going to go well. I don't want you to have any threatening or harassing contact with them. What is threatening or harassing doesn't matter what you think. It is what they perceive. So if you go like this, is that threatening or harassing? It most certainly is. And it can land you back in jail. Do you understand? So if you cannot be nice and if you cannot get along with brother and sister or dad, be very careful. Because if I get wind that it's not going well and that you're threatening or you're putting anyone in danger or you have a weapon, I will put you in custody. You understand? Okay. All right. I'm done.
Thank you, Judge. I'm excused.
The only, Mr. Albardan, the only thing I'm taking off of the protective order is the residential restriction. Everything else in the protective order stays. So if you threaten them, if you harass them, they can charge a new case on you. Do you understand?
Yes, ma'am.
Okay. All right. And if you can file, no, now we need, yeah. So, Ms. Reedy, we need new bond conditions. He can't leave just yet, so we need him to sign no threatening or harassing.
Right there, not to leave.
Okay.
Yeah.
Stay.
I heard.
Okay.
How are you, Judge?
What's new, man?
Same old.
Did you can pick a day?
Well, I have Monday and Tuesday are not good for me. Wednesday or Friday of next week is fine. I mean, I have a few days every week. Just
All come together for the meeting of the minds?
I think it's from what it sounds like, our officers we need two officers. One is,
One is unavailable on Wednesday and the other officer is unavailable on Thursday and Friday. I've reached
So
out.
go into the next week.
Yes, yeah, okay.
I don't care.
Both of them should find out their availability for next week. I'm just waiting to hear back. The next week after that.
Okay.
Yeah.
okay.
No stress, man. We have enough drama. Just pick a day. I don't care.
I'm not
just
looking
make
for
sure that, like, I don't want to keep doing this stuff. This is like, this is the last time.
Before we said, hey, go to the next week.
If we set this for the next hearing and one of the officers comes back and says, I'm sorry, I can't do it. I don't give, we're going forward without that.
Understand, Your Honor.
All right?
All right.
Whatever you want,
All right.
of course.
Sure.
Ralph,
Oh, yes, sir.
hey,
I've got Mr. Basie and the state,
Following review of the settlement agreement and governing procedures, the court resumed discussion concerning the constitutional sufficiency of the sworn statement. Defense counsel reiterated that the dim summary is intended to contain all essential facts and expressly prohibits reference to external reports. Counsel emphasized that, as a warrantless arrest, the Fourth Amendment requires a neutral magistrate's determination based solely on facts supported by oath or affirmation. Because the offense report lacked such an oath, counsel argued it could not be used to cure deficiencies in the DIMS. The prosecution contended that offense reports constitute official government records, and that falsification would itself be criminal. Nevertheless, the court distinguished between general reliability and the constitutional requirement of sworn testimony. Judge Fletcher referenced the county's prior settlement, explaining that Harris County had agreed to hold probable cause determinations to a higher sworn standard. The court expressed reluctance to depart from that agreement and indicated that it would rely strictly upon the sworn DIM's entry before issuing the ruling. The judge addressed Mr. Laws directly, admonishing him for failing to comply with prior bond conditions requiring installation of an ignition interlock or portable monitoring device. The court warned that future noncompliance would carry serious consequences, underscoring the seriousness of public safety concerns.
would like to evaluate it. It's an old case, Your Honor, but they asked if we could reset it, which I'm in agreement.
this is an interesting one.
Right, it really is.
A week. We filed for a week.
Yeah, sure, yes.
Do you have an offer on the case?
Just want to do one, just the,
Yeah.
I just want to do one little case law
Not a problem.
thing. I think.
Is discovery complete?
It's gonna be complete.
You've got an offer?
I think we're gonna be able to resolve this case.
Okay, so I guess set it for next week,
All right, sir.
and then we'll come back
I
and,
just want to do one more little case law.
no problem.
Sure. Thank you, Bob.
Hi, Ralph.
Thank you. Sir.
Hey, Anna, come on. So you're saying that it doesn't, the DIMS has no reason for the stop, right? Is that what
Yes.
you're saying?
The sworn statement, and speaking with Ms. Rogers, we're looking, but it's not,
And I'm looking to.
okay.
I am too.
There was a class action lawsuit, and as part of the settlement, the agreement was that Harris County would use the DIMS to support
Okay,
PC, but we're getting that all together.
me too.
Okay.
For the 26th. All right, there you go. You're good to go. You're welcome.
Was there a result for that?
Yes.
Or is it in action now?
No,
No, this was some time ago. So this was before the DIM summaries had an oath or affirmation at the bottom of it. So there was a class action lawsuit brought by the Civil Rights Court. And out of that lawsuit, it was just allegations of Fourth Amendment violations, because when a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an oath or affirmation.
Okay.
So I think it is a Fourth Amendment issue.
I'm curious, so I'm curious, for PC purposes, can state use an offense report to supplement a DIMS? Or are we strictly going in the four corners of the DIMS and nothing else? I don't know.
well, the four corners of the DIMS is what's sworn to, the offense report is not sworn.
I find that really weird. How is it that they're creating an offense report and they don't swear to it? You know, because there's, in the offense report, you also have a search warrant. Like 9 times out of 10, you've got a blood search warrant, and that's sworn to.
That, Your Honor, if the officer makes something up into the office report, he is committing a crime. So I mean, I don't say that the office report is not sworn to, it's a government record that this officer is putting his name on. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is a different crime than perjury.
I get it, but
Wouldn't that be filing a false
Right, but perjury's
unofficial document?
a different crime.
No, but it would also under the purview of filing a false,
Well, Judge, if an
Filing a
officer
false-
came into court and was asking for you to sign a search warrant and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea. Because this is a warrantless arrest, there has to be someone pointing to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by oath or affirmation. This wasn't a warranted arrest. It was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
Was there blood in this case? Right. Okay, give me 5 minutes.
Okay.
Huh? Okay,
If it's okay with you, we'll take.
can
a
you
look.
show them?
yeah, that's fine.
Hey,
Plea for you.
Last name is Bledsoe.
Letza?
Bledsoe.
Okay, you want to bring him on? Are we going on the evading and the terrorist act that's going to be dismissed? Good morning, Mr. Bledsoe. You were charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're going to dismiss your terroristic threat in exchange for your plea on the evading arrest. You need to understand that evading is an enhanceable offense. This is going on your record today. It'll be there forever. From now on, if you ever run from the cops again, you'll be facing a felony charge, years instead of days. Do you understand?
Sir.
Not only that, it's a minimum now of 90 days for any new cases that you pick up in here. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it stays on your record forever. Is this what you want to do?
Yes, Your Honor.
How do you plead to the offense, sir? Guilty or not guilty?
Good sir.
I'm going to find you guilty. I'll sentence you to the agreement. If it's enhanced, it'll be abandoned. Good luck, sir.
Thank you, Judge.
Anna.
I'm working with Mr. Gladstone.
Anna, you ready?
Yes, Judge.
Mr. Laws, come up. We have court orders for a reason, and when you don't follow court orders, bad things happen. Do you understand?
Yes.
You were ordered to get an interlock and you didn't get it, or a portable device, and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right, good luck.
Thank you, Judge.
I think that we are,
Sorry.
it's okay. No, and I think you're right, we were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to, I want to stick with the agreement that the county came to with the district attorney's office,
So, I'm not saying do this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over because shit, you might get like 15 supplements.
Here's my question for the court.
And I'm not saying we do this on this case. I'm just saying for cases going forward. To me, then, does that then behoove, does that say we can't take it to grand jury? I mean,
You can, of course you can.
So,
Just because I find no probable cause on something, if you want to go indict it, go do it.
right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them. As far as me, I'm going to just hold to the standard that we agreed with the county in the lawsuit.
Yeah, I'm just saying this is for my own.
And you're not going to hurt my feelings if you go to a grand jury. I don't care.
I know you do. I just, so we wouldn't be held to that same standard.
You need to do what you think is right.
Okay.
Like I'm going to do it and like
Absolutely.
she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did, Not everybody is,
This is required to
I understand.
which is good.
Thank you.
God love you.
Judge Fletcher ultimately determined that the sworn DIMS report failed to establish sufficient probable cause for the warrantless arrest. Because the document did not include the factual basis for the traffic stop or otherwise set forth all essential elements demonstrating lawful grounds for detention, the court found the constitutional requirement unmet. Accordingly, the court ruled that no probable cause existed to sustain the pending charge under the current procedural posture. However, the court clarified that this ruling did not bar further prosecution. Since the case had been initiated by information rather than indictment, the district attorney retained the authority to present evidence to a grand jury. The judge explained that a grand jury could independently determine probable cause based on sworn testimony, and if at least 9 of 12 jurors agreed, return a true bill of indictment. Thus, dismissal at this stage did not preclude refiling. Subsequent to the court's ruling, the state moved to dismiss the charge while reserving the right to refile at a later date. The court granted the motion and formally dismissed the case. As reported, Harris County prosecutors had not refiled the charge at the time of documentation, leaving the matter unresolved but procedurally closed pending further action.